Mediation. We're going to get started. All right, Katie. All right, let's talk about mediation. Just from a basic standpoint, what is mediation?
So the actual definition of mediation is that it's a voluntary, informal process where a trained, impartial mediator assists parties in reaching a mutually acceptable resolution to their dispute. So mediation here is an alternative to the normal OOR appeals process where parties would submit arguments and have a final determination issued. Both the requester and the agency participate in the mediation session, and it's up to the parties themselves to decide if they could agree to resolve an appeal. So unlike some other forms of dispute resolution, in mediation, the mediator does not decide the outcome of a mediation and does not make any determinations or offer any type of legal advice. Mediation is a confidential process, so all discussions and materials created during the session is kept confidential. It's not shared by the OR, it's not public, and it can't be used in evidence in another proceeding.
So what I'm hearing is typically when we get an appeal, it's an exchange electronically of emails and documents, not over the phone, not face-to-face, but just an exchange that way. And mediation allows you to, I would say sit in the room, but virtually sit in the same space, potentially, or on the phone, face-to-face on virtual discussions, and talk about the issues at hand rather than just having a back and forth in emails. Is that a good description?
Yep. We've been using Microsoft Teams for all of our mediations, and it's been going well.
Good. Okay, so let's talk about, what happens during a typical mediation session.
So we ask all parties to come to mediation in good faith with an open mind, and that they have authority to settle any pending appeal at the time of the session. All parties are given the opportunity to speak without being interrupted regarding any outstanding appeal issues. So at the start of the mediation session, we ask all participants to identify themselves, and then the mediator goes over general mediation guidelines regarding confidentiality, the mediation process for if an appeal should be resolved or not resolved. And then once the parties all agree to the guidelines, each party is given an opportunity to give a brief opening statement. That helps everyone identify the issues to be resolved. Normally the requesters will go first and then the agency responds. And then at that point, the discussions just start back and forth between the parties. And in our experience, parties are generally very respectful of one another. They get along, the discussions are non-adversarial. Mm-hmm. And then there are times when during the call, the mediation session might not be able to be resolved that day. Sometimes this is because the agency might need to check for records, or maybe the requester needs time to review records that were provided. So if that happens and it can't be resolved that day, if everyone agrees, we'll leave the mediation open. And oftentimes the mediation can then be resolved over email within a short period of time. Sometimes we'll set up a second call if that's necessary, though. So as long as the parties are working together to resolve the matter and agree to the timelines, we're pretty flexible about leaving a mediation pending and, letting the parties work things out.
So unlike a standard appeal, there's not that 30-day deadline that's staring you in the face.
Correct.
Okay.
Yeah, all deadlines are stayed, which just means nothing happens during that time.
Good. And I forgot to mention, if you have questions, feel free to drop one in the chat. We're either check in. Occasionally we may miss it, not get to it immediately, but we will be happy to answer any questions as they come along. Okay, so let's say you do an appeal. You do a mediation, appeal during mediation, and it's resolved. Both parties come to an agreement to share certain records or whatever it may be. What happens at that point?
So at that point, what we do is we ask the requester to withdraw their appeal. And that just means that no further action would be taken by the OR with that matter.
Okay. And what happens if the parties can't come to an agreement? Even though you've tried, you've talked, you've worked through things, there's still a stalemate on one or more issues.
So if an appeal can't be resolved, the matter is just reassigned to an appeals officer for the issuance of a final determination. Once reassigned, an appeals officer will reach out to the parties. They'll set new deadlines for the final determination for arguments to be submitted.
Good. And let's say you decide to try mediation. You've never tried it before. You say, let me give this a try. And it's going along. You decide, you know what, this isn't for me. Either this issue isn't working out for mediation, or I just don't have the time. For whatever reason, you don't want to continue to do mediation. Is it over for you? Do you have to start the process again, or what happens with your records request and appeal?
So at any time, because this is a completely voluntary process, any party can decide to terminate the mediation. They don't have to give a reason. They just say, you know what, I don't want to do it anymore. And at that point, the matter would just be reassigned to an appeals officer. So there's really nothing lost. It just goes back through the normal process.
And you still have those 30 days at that point, or wherever it was when it became, okay.
Yes.
Okay. All right. So how does it work? Let's say I submit a right to know request. I'm denied records. I think I'm going to appeal it. And I say, you know what, I think I'd like to try mediation. How does that work? How do you participate in that?
So mediations are open to all parties before the OOR. When you file an appeal with us and you use the OOR's appeal form, there's a checkbox option that asks if the requester is interested in mediation. So if that box is checked, the OOR stays the appeal for 7 business days and sends out a mediation form to the parties in the standard notice of appeal packet that we send out whenever an appeal is filed with our office. So if the parties wish to participate in mediation, they should review that form and sign it. The form itself just indicates that the parties agree that the session is confidential. The requester will withdraw their appeal if the mediation is successful, and that if it's not, the parties agree to give the OOR at least 30 days or more if the requester agreed to an extension from the date that mediation concludes to issue the final determination.
And what happens if the requester is interested in mediation and the agency is not?
So both parties have to agree to mediation. So if only one party does, then it would go through the normal process.
Okay. And do you have to be an attorney to participate in mediation as a requester? Do you have to be able to speak legalese and know all the ins and outs of the right to know law?
Not at all. So our attorneys are certainly permitted to participate in mediation, and they do. Oftentimes, agencies will have attorneys, but you don't need to have an attorney. You don't need to be an attorney. A lot of times our requesters are not attorneys. So like I said, it's a pretty informal process. So we try to make it as easy and accessible as we can for everyone.
Okay, I think we got a question. If we could tap on that. There we go. Yep. Does the mediator give the parties information about the state of the law, what's public, what's exempt? Agency lawyers often know the law, but requesters are mostly non-lawyers. Would this help even the playing field?
So we do not. Like I said, the mediator, we don't offer any legal advice or try to influence the decision in any way. Now, if they're very standard, exemptions or something like that we can give, we will, but we generally don't give any type of information. I'll always point the requesters or parties to our website where you can see all of our final determinations and you can search by issue or exemption.
Great. Where are we? We're talking about the length now? We still, okay, I think we're there. Let's see here.
Oh, and yeah, just going back and how you would, get involved in mediation. There are some times when, maybe the parties didn't check the box, but maybe the appeals officer gets the file and they think it might be a good candidate for mediation. So they might, suggest it to the parties. It's still up to the parties to decide if they want to do it. But oftentimes we can get cases that way too. And anytime before the final determination is issued, any party can request mediation. So you can be a couple weeks into the process and then say, hey, I want to try this, and that's totally fine. You could just let the appeals officer know.
If you do try mediation and decide not to continue it, does the appeals officer know what was said and talked about during the attempted mediation?
No, absolutely not. It's a totally separate process, and we do not share any information besides the fact that the case was in mediation and whether it was resolved or not. That is the only information that would go from a mediator to an appeals officer. So you're kind of, just so everyone's working on a clean slate and there's no influence either way. Yeah.
And in fact, you, Katie, as our head of mediation program, you don't talk to other attorneys in your office about anything that's discussed.
No, absolutely not. No one knows what I do all day.
Good. So how long is the mediation process? How good is it? Does it vary, or is it sort of a standard time?
It varies depending on the nature of the case, but in general, mediation could be a very quick process. So that's one benefit to it. Once mediation agreements are signed and received by the OOR, the mediator generally will contact the parties within 2 business days about scheduling a call.
Okay.
And then depending on the availability of the parties, we try to schedule a call within 2 weeks. Some cases sooner if everyone's available. So an appeal where parties participate in mediation, it could potentially be resolved within 2 weeks of a signed mediation agreement, whereas final determinations, as we know, can take up to 30 days or longer.
Great. We already talked about attorneys. Let's put number 4. So why should someone consider mediation? Why should that be something you consider when you are trying to appeal a denial of records?
I think there's a lot of benefits to trying mediation. There's no cost to participate in the program. Like I just mentioned, it could be much quicker than the normal appeals process. Because mediations are quicker, the parties aren't required to submit written arguments or evidence like they would be if a final determination was being issued. And that saves time and expense. That might be in the form of attorney's fees, maybe costs associated with if there's appellate proceedings after a final determination. Some parties like it because, like I said, as mediators, we don't make determinations. So the parties themselves control the appeal rather than having our office issue a final determination. Another benefit we see is the parties can develop relationships, and open dialogue, and just know that everyone's working in good faith to utilize and comply with the right to know law.
Yeah, I think that when I talk to people about it, I think about some things in life. You should just stop texting and pick up the phone and call somebody. Yeah. Sometimes just having a dialogue makes all the difference in terms of tone and the kind of questions you can ask and narrowing down what kind of information they're getting. It just sometimes makes sense to, I think, chat about it versus just exchange emails and arguments.
Yeah, we find a lot of times once parties just sit down and talk to each other, these appeals and requests can resolve really quickly.
Good, good. So it seems like there's really not any disadvantage to participating in mediation. You don't lose anything.
No, not at all. There's really not a disadvantage. Like I, had mentioned before, if an appeal is not settled during mediation, it's just sent back through the normal appeals process, and the mediator doesn't share any type of information with the appeals officer or anyone else in the OOR for that matter. The only information that's shared is whether the appeal was resolved or not. This is because mediations are confidential, and also just so, again, everyone just has a clean slate, and there's no appearance of bias or anything like that. And everyone gets to make their arguments to the appeals officer. So we really try to make sure there's no disadvantage at all in participating in mediation.
Good. Good. So next, I think it'd be helpful. We talked about what mediation is, why it can be advantageous, how you're not really risking anything by giving it a shot. What are some examples of appeals that have successfully been resolved through mediation? And before Katie talks, I mentioned because of the confidentiality, we're not talking about specific real things that happen, but sort of generally kind of what kind of situations are ripe for the mediation process, perhaps helping.
Yes. So we see a lot of requests to police departments. So an example is the family of an individual who passed away was looking for investigative reports and materials from the police department related to the death. The police department, of course, is going to deny that request as investigative materials. which is appropriate. However, through mediation, there are instances where just, again, getting those parties together in a room, they talk through, and sometimes it's outside of the right to know law, but the police department says, hey, we actually can share this information with you. So, that information is helpful to the requester, and the type of instance I'm thinking of, it, type of closure for the family of the deceased. So that's a good example.
Because the right to know law says that they don't have to release that information, but they're not prohibited from it. So they can talk to the family and get a sense of what really they need to see, and maybe even just show them the records and not give them to them. There's ways to kind of perhaps reach an agreement.
Absolutely. Yep. Another type, again, we have a lot with police departments. So there was once recently a landlord of a property was looking for records related to a property. And again, there were some investigative materials that couldn't be given out, but through the parties coming together for mediation, they realized, well, there actually is some information that we probably can give you. And without sitting down and talking, that information would probably never come to light. So in another instance when mediation, I think, works out really well is sometimes requesters might submit a really broad request. We might even call it insufficiently specific. And the parties getting together and talking, they can narrow the scope of that request and the subject matter. And instead of the requester getting hundreds of records that they didn't even want in the first place, and the agency spending, a lot of time going through records because they're not sure what the requester's wanting, the parties can, talk about what they're actually looking for, and save everyone some time, and the requester gets the records they're actually looking for.
Good. All right. So now we're going to talk to someone who has participated in some successful mediations. Let's see here. We got to figure out our technology here.
Hey.
There she is. All right, Paula. All right. So Paula Knudson Burke, why don't you introduce yourself and who you work for, and some give a general overview of your experiences with the right to know law, and we'll talk about your mediation experiences.
Sure. Thank you for having me on. I am the local legal initiative attorney for the Reporters Committee for Freedom of the Press. That's a lot of words. But basically, the Reporters Committee is a nonprofit in Washington, D.C. And several years ago, the organization decided to place lawyers in high-need states. So we have lawyers on the ground. I'm the Pennsylvania lawyer. We have Oklahoma, Tennessee, Colorado, and Oregon, and we help reporters, print, broadcast, TV, radio, you name it. And so that brings me into the sphere of a lot of right to know requests, and sometimes into the sphere of mediation. So I also work a lot with my colleague Melissa Maluski from the Pennsylvania News Media Association in counseling journalists who are trying to decide, do they want to go to mediation, and what that looks like for them, if it's a good choice.
Great. All right, Katie, you have some questions, I think, for Paula.
Yeah, Paula, we'd love to hear some about your experience with us. I thought maybe we could start by you letting us know how you and your clients come to the decision to either participate in mediation or maybe not to participate in mediation.
Yeah, I think when Liz had her introductory comments, she talked about sometimes mediation isn't a good choice. And there may be cases where for some reason the relationship was more antagonistic between the agency and the requester. Maybe that's not the best choice for mediation. For reporters in particular, sometimes they're concerned about the confidentiality provision of mediation. So reporters, by their very nature, are trying to report out a story and give that information to the public. So if there's something really juicy that happens to the mediation during the mediation, that can be a little bit frustrating for the reporter who knows that she can't then report on that content. So that's another factor that reporters in particular might think about in choosing whether or not to enter mediation. Another thing we talked about earlier, Katie, you were mentioning time frame. I do think it can be quicker. There might be times where the mediation goes on and for whatever reason it breaks down, then the clock restarts. So if there's someone who really is anxious to know what the clock looks like and to have that 30-day clock running, mediation might not be the best choice. And then also I think the nature of the request, if it's really, really complicated, maybe it makes sense to talk it through, but perhaps it's best just to leave it in the hands of a regular OR proceeding. But the flip side of that is I've worked with reporters who have had, let's say, one document that they really want from the agency, and somehow there's been some lack of communication or understanding on the two sides about what it is. Reporters often want a machine readable format, so an Excel spreadsheet, for instance. And I didn't participate in this mediation, but I heard of an instance where the agency was concerned that if they gave the Excel spreadsheet to the reporter, that the reporter would then be able to manipulate the agency's computer system. And so just kind of talking that through and saying, no, listen, the reason we want that is we have data journalists on staff who work with this and can do a visualization for the readers and the viewers, and it's helpful. And then it kind of crystallized for both sides that there were good reasons why that document should be turned over, and it wasn't going to be damaging, but rather would be helpful for the readers and viewers to find out this information. So I think that checking the box of mediation, and I will plug the OOR fillable form for taking an appeal. It's really easy to use, and there's a little box that says mediation. Think about, I think on the requester side, we have to think about a variety of factors about whether or not mediation is appropriate, but it definitely should be in the mix of thinking about. And, the outcome can be really outstanding if you get a document you're looking for or something like what you were looking for through that mediation process. And I'll also give a plug for the Commonwealth's Court mediation program. If a case goes up beyond OOR, the Commonwealth Court also has a mediation program that's effective. So I think, to your question, Katie, there are a lot of factors. It depends, but I think most requesters should absolutely consider it as a possibility.
So can you tell us, Paula, generally how your experience has been with the OR mediation program? And maybe you kind of just mentioned the spreadsheet case, maybe if you had any other, success type of stories, of course, without going into detail.
Yeah, I think, unfortunately, there have been some less than favorable comments over the past number of years levied toward members of the media, and sometimes that kind of trickles down, and there might be a sense among the agencies that this is bothersome or it has an ill intent. And I think once the parties get together in that mediation, and sometimes an editor will attend along with the reporter, and they'll say, listen, we really don't want to make your life agency open records officer harder. Here's where we're coming from. We're working on this story, and it would be helpful for us to illustrate it with X information. Just having that dialogue to explain to the agency that the reporter isn't trying to be pesky and that she has a specific reason. Now, of course, we know that no requester has to tell the agency why they want the record, but in that mediation setting, sometimes giving the context of where the requester is headed with the document can be a helpful conversation. So I've seen that play out well, where there's a little bit more context, because of course just a form, sending it to the open records officer doesn't tell you a lot. And as Liz said, kind of getting outside of the space of simply writing things down or emailing things and really listening to each other can be very helpful. And the role of the mediator in these OOR mediation sessions is great because they'll say, okay, requester, we heard from you. Now let's respond to that. Can you tell us, agency, what your concerns are? So really having that space and time to flesh it out in a manner that is different than just that sheet of paper can really help.
Based on your experience, do you have any tips maybe for how to reach a successful resolution during mediation, or maybe some tips what to avoid to be unsuccessful?
Yes, I think keeping those open channels of communication with everybody involved in the mediation and making sure that you're providing them with enough background. So if there's a particular document that the requester knows exists or has a basis for requesting, maybe giving an outline or a memo, preparing that and sending it the day ahead to say, hi everyone, I know we have the mediation tomorrow, and it doesn't have to be anything fancy, just some bullet points. Here's some of the things I'd like to talk about tomorrow, and even linking out. So linking out to something that the requester will be referencing, just to make sure it's a productive session, and particularly if it is a more complicated session that 10 o'clock on a Wednesday rolls around, and as the parties get together, an email is sent out at 10:01 saying, here's all the things I want to talk about today. That's not helpful. So giving space and time for everybody to digest what's happening, because then I think, Katie, typically we're about an hour for those mediation sessions. I mean, you can get a lot done in an hour, especially if you've exchanged some background information ahead of time. So I think that's the biggest tip, is just making sure that everyone understands what your goals are for each side and narrowing it down.
Yeah, and you're right. And I meant to actually point that out, that most of our mediation calls are an hour or less. So oftentimes if, it's only one issue, we might be done in a half hour. But of course, there's always time set aside, so we could go longer than an hour or two. So you kind of already touched on this, but and I think I know your answer, but so based on your experience, would you recommend parties try out mediation?
Yeah, as I said, I think it's always worth considering, and there may be factors for certain requests that simply don't point to that as a viable option. And look, nobody wants to waste your time as the OOR mediation officer or each other's time. If everyone knows going into it that the parties are really set in their position, no, you're not ever getting this record because whatever reason, that we firmly believe it's a pre-decisional record, you're just not going to get it, and the requester just absolutely firmly disagrees, that's probably not going to be productive. But if there's been a sign or any kind of discussion during the agency proceedings that might leave a window, I think it's worth considering.
Good. All right. Thank you, Paula. Let me just make sure we don't have any. How do you check questions? Let's see here.
I think over to the.
There we go. I think we're good. Well, thank you everyone for joining. Paula, thank you for sharing your experiences with us.
Happy Sunshine Week.
Woo! Yay. And we hope that everyone will consider giving mediation a try if it seems like it's a right situation for that. And we will be back tomorrow at 2 o'clock. We're going to be talking about trending topics, things that the whole world's been talking about the last 2 years that we see in our appeals all the time, things about mask policy in schools, about election results in 2020, all sorts of things. What kind of things come into play when we get lots and lots of requests for records related to those. So we look forward to seeing some of you tomorrow, and we will see you then. Take care.
Thank you.